James got rear-ended on the Southern State Parkway. Herniated disc, 6 weeks out of work. Clear liability. The other driver ran right into the rear. His medical bills were over $80,000. Insurance offered him $22,000. The question every person in that situation wanted answered is, how much is a car accident case worth in New York? The answer is never simple. And the factors that drive value up or quietly destroy a case are things most people never learn until they've already made the mistakes. There's also a New York law that most drivers have never heard of, the serious injury threshold, that determines whether you can even sue for pain and suffering at all. We're covering all of it. New York is a no-fault insurance state. That means that after most car accidents, your own insurance pays for your medical bills and lost wages up to the coverage limits, regardless of who was at fault. That's the no-fault system. No-fault pays usually up to $50,000 in medical bills and lost wages. That sounds like enough. On a serious accident, emergency room, surgery, inpatient stay, months of physical therapy, $50,000 can run out before you're done treating. When no-fault benefits are exhausted, your ongoing medical costs come out of your pocket unless you have supplemental coverage. This is why understanding your own policy limits before you ever get into an accident matters. Most people have no idea what their own insurance actually covers until they need it. What no fault also means is that you cannot sue for pain and suffering simply because you were in an accident. You have to clear a threshold first. Under New York insurance law, section 5102D, to bring a claim for pain and suffering outside the no-fault system, your injuries must qualify as a serious injury under the statute. What qualifies? Significant limitation of use of a body function or system, permanent consequential limitation, fractures, significant disfigurement, or a medically determined injury that prevents you from performing your normal daily activities for at least 90 out of the 180 days following the accident. Most moderate to serious car accident injuries qualify. Herniated discs with significant functional limitation typically qualify. A soft tissue strain that resolves in a month? Probably not. Insurance companies know the threshold better than most injured people. Their strategy in borderline threshold cases is simple. Hire an independent medical examiner, a doctor who performs defense exams almost exclusively, who will examine you once, review your records, and opine that your injuries are resolved or your limitation is minimal. Their goal is to keep you below the serious injury threshold, out of court, and settled cheap. The counter to that is documentation, not just the emergency room visit. Consistent, ongoing treatment with a physician who tracks your functional limitation over time. If your injury genuinely limits you, that limitation needs to be in the medical record. The IME doctor can dispute it, but they can't erase years of treating physician documentation. This isn't the system most people expect. They think, I was in an accident, I got hurt, I could sue. Sometimes, if you clear the threshold. Before we talk about what a case is worth, liability has to be established. Who's at fault and by how much? New York's pure comparative negligence system means your recovery is reduced by your percentage of fault. If you're found 20% at fault, your recovery drops by 20%. Clear liability. One driver ran a red light, rear-ended you at a stop, is worth more than a disputed fault situation. Insurance knows this. When liability is murky, they have leverage. Economic damages are calculable losses, past medical bills, future medical treatment, projected over time by your treating physicians, lost wages, documented through pay stubs and tax records, lost earning capacity if the injuries are permanent and limit your ability to work going forward. These numbers are provable. They form the floor of any case. If you have $80,000 in medical bills and 3 months of documented lost wages, those numbers go into the calculation. Insurance has to account for them. The question is whether they'll value them at the actual cost or argue they're inflated. These aren't abstract numbers. They come from medical records, treating physician testimony, and, frankly, how well the story is told and documented. Long Island cases often involve longer treatment timelines than city cases simply because distance to specialists affects how quickly people get follow-up care. That gap in treatment, 3 weeks between visits because the orthopedist is in Garden City and you're in Smithtown, becomes an argument for the insurance company that you weren't seriously injured. Document every appointment. Document every time you called to schedule and had to wait. The medical record doesn't capture the whole story on its own. Your attorney builds the complete picture. New York allows recovery for pain and suffering in cases that meet the serious injury threshold. There's no statutory cap on pain and suffering in New York. But what drives pain and suffering value? Duration of the injury, severity of the impact, how the injury changed the person's life. Age matters. A 30-year-old with a permanent injury carries that for decades. If case value and settlements are what you're focused on, the car accident settlements video earlier in this series goes deeper on what those numbers look like at the negotiating table. Link in the description. That wraps the first 10 videos. Browse the channel, watch what fits your situation, and subscribe so you don't miss what's coming. Cohen and Jaffe handles personal injury cases across New York and Long Island. Contact information is in the description. Drop a comment. What question do you still have?